Be seated. Next case is, of course, a case of Manuel Valle, appellant versus the state of Florida. Counsel for the appellant may proceed.
Please, court and counsel. Your Honor, my name is Stephen Michael Kissinger. I am attorney for the appellant in this case, Manuel Valle. We have submitted briefs on this matter containing a number of issues. Today in argument I intend to address primarily two of those issues, although in the course of covering one of those issues, a number of other issues in Mr. Valle's appeal may well be addressed. The issues which I would like to address are issues one, involving the denial of an evidentiary hearing.
Mr. Kissinger, I'm just for my information.
Yes, sure.
You were the counsel in the trial court?
I was counsel before the circuit court, yes, Your Honor.
And as I understand the chronology of events here, this hearing, the Huff hearing that we're dealing with, was in August of '94.
That's correct, Your Honor.
And the motion for rehearing was denied.
That is correct,
January of '95.
I believe that's correct, Your Honor.
Well, what I'm curious about is why was there no notice of appeal filed until June of '96?
Your Honor, I believe what happened in Mr. Valle's case is that the orders were not served upon Mr. Valle in accordance with Rule 3.850.
You didn't receive the order?
Not until very late, Your Honor. We filed it within 30 days of the date we received the order.
The order was entered in January of 1995, and you did not receive the order until May of 1996?
That's correct, Your Honor. There was a problem in terms of having the clerk send the order out and send out the certified copy, the order. They use a little stamp, actually, which says that this certifies that this order was entered on this date, and they send it to you, and that order was not entered in a timely manner, Your Honor. All right, that was not served in a timely manner by the clerk.
Thank you.
Your Honor, proceeding to issue number one regarding the failure of the trial court to afford Mr. Valle an evidentiary hearing based upon the allegations put in his Rule 3.850 motion. It's clear from the record that the trial court violated the most basic precept of post-conviction pleadings, which is that the allegations taken in Mr. Valle's, the allegations made in Mr. Valle's brief, or his motion, are to be taken as true unless conclusively rebutted by the record. If the court examines the record in this case, it will see repeated instances where the trial court stated over and over again that it was not going to just rely on these allegations, that because Mr. Valle did not submit affidavits, because he did not produce the names of the witnesses who would testify at hearing, and because of a number of other factors, he simply wasn't going to believe them. There is an extended colloquy which is set forth in our brief where the trial court expresses dismay. Paraphrasing what happened with how the colloquy went, the trial court says, suppose that Mr. Valle were to file a pleading which says that the trial judge was involved in intimate relations with the victim. One of the allegations in Mr. Valle's motion was that the trial judge kissed the victim of the widow in the presence of the jury. But the court took it a step farther in its example. Said if Mr. Valle were to allege that, do I have to give him a hearing? And what I told the trial court and what the law in this state is, if it serves as if that would constitute a grounds for relief, yes.
Well, let me ask you. I understand, the law that you're applying. Wouldn't it have been a lot easier just to give him an affidavit or tell him who the witness is? We wouldn't have had to worry about all this.
Well, Your Honor, I would agree that yes, that would have been easier, possibly,
Well,
but
it's kind of a bizarre allegation. You got to admit that. It's not as bizarre as the one he outlines, but it's a little off the wall, and I can understand why he was raising his eyebrows at it. Can't you?
Your Honor, I can understand any court's skepticism on any allegation, maybe even in particular an allegation such as this. However, again, the law is clear, and I would like to.
You know, we got two years we're messing around with this, and I think, and I'm assuming you wouldn't, you know, if you didn't have any basis for it, you'd be ethically in violation. I'm assuming that you got a basis for saying it. All I'm saying is, why don't you just tell them who it? You got a witness, you got an affidavit, whatever, and then we move on.
Your Honor, I believe actually during the course of that argument, we may have identified, not by name, but by description, who the witness was. We also, by description, at least described who the witness was and how they would have personal knowledge of that in our motion for rehearing.
And how was that? What was that description?
Your Honor, I believe that, again, it's while we did not specifically refer to the use the word kissing, and it's contained in paragraph 7. It says, as to claim 6, which is the claim containing this allegation, trial counsel would have testified from personal knowledge both as to the fact of the ex parte communication between the attorneys for the state and trial judge and the trial judge's improper conduct for the jury vis-a-vis the wife of the victim and female police officers. He would have further testified that the failure to object was due to either neglect or oversight, not any strategic decision not to object.
It's an allusion to trial counsel.
Yes, trial counsel would be the witness to provide that information. Interestingly, trial court, when it heard this allegation, even remarked, if this was true, the court would have to look at granting relief, would have to seriously consider granting relief. Well, that's the point. If it was true, Mr. Valle is going to be entitled to relief. Again, we have allegations regarding ineffective assistance of trial counsel for presenting prison behavior, or what we all know now as skipper evidence. The court, rather than taking Mr. Valle's allegations as true, and what Mr. Valle alleged is that was that trial counsel put in this evidence because he mistakenly believed that he was required to put in skipper evidence because that's what he got relief on. We allege that that was the reason he did it. We allege that the reason that trial counsel, and that trial counsel wouldn't have done it if he had known the law. Well,
Something anomalous here. You got this reversed for failure to be able to present skipper evidence.
that's correct, Your Honor.
And now the premise is that you're trying to get it reversed again because he didn't put on, that he chose to put on skipper evidence. Isn't there something a little anomalous in there?
Well, Your Honor, I see what the court's saying, except for the small problem is that in the intervening time, in between the time he got skipper evidence, or he got relief on skipper, or when he initially wanted to present the skipper evidence, and the time he went back to resentencing, there was a small problem. And that small problem was Mr. Valle's attempted escape with Mr. Bundy. What Mr. Scherker will testify to is that if he felt that he was not required as a matter of law to present the prison behavior evidence, he would not have done it. It was based solely on ignorance of law. He received a new sentencing hearing. It's relief. There's nothing in the case law of this court. As a matter of fact, the case law of this court, at least when you look at the prosecution side, it's to the contrary. We look at the clean slate rule. You get a new sentencing, it's a brand new proceeding.
A a lot of this is laid out in the trial record. Apparently, there was a disagreement between the counsel.
And, Your Honor, and that goes to one of the state's asserted defenses regarding this particular claim, which I think needs to be addressed, and that's that somehow Mr. Valle had waived the right to present this claim. And I think what the court needs to keep in mind is that the state provided Mr. Valle with an attorney. And if that attorney goes to Mr. Valle and tells him something that is untrue and incorrect, and Mr. Valle relies on it, that's not waiver. He has a right to rely on the information that the state provided to him, because that's what an attorney is. That's what an appointed attorney is. That's the state assisting Mr. Valle. The state comes to Mr. Valle and says, you have to put this evidence on. There is no waiver on the record. There is no discussion on the record whatsoever about Mr. Valle saying, I want my prison behavior evidence to be presented. It's not on there. It just says, I'm agreeing with Mr. Gelman leaving. This hasn't been waived. There's no waiver on the record. Waiver has to be clear and unequivocal. Here, there's nothing. Here, they're simply letting one counsel go. Whether it was over a disagreement of counsel is irrelevant. Just because Mr. Valle allowed Mr. Gelman to leave doesn't relieve Mr. Scher and his co-counsel of the obligation to properly advise him of the law. If Mr. Scher had improperly advised Mr. Valle of a possible plea agreement, this court would grant relief. If he had improperly advised him as to any other factor, this court would grant relief. Just because Mr. Gelman left doesn't waive his claim. So there is no waiver on the record of the claim. The second matter, and again, I think I probably share the frustration that Justice Grimes expressed earlier regarding the length of time that we have looked at here. This case, I would hope, is one of the last cases that this court will see that has been delayed by the fairly unwieldy public records process which existed at the time. In this case, Mr. Valle was pursuing civil actions in Leon County Court against two entities, the Department of Corrections and the Florida Department of Law Enforcement. The trial court, rather than let him complete those actions and get the information from those agencies, said, no, I don't have jurisdiction over them, and we're not waiting anymore. There's nothing in the record in terms of why those actions took so long to litigate, but it wasn't an issue with the court. The court didn't care why it took so long. If the court had bothered to inquire, it would find out that part of the reason that it took so long to litigate these actions is because the Department of Corrections and Florida Department of Law Enforcement came into court here in Leon County and said the Office of the Capital Collateral Representative was not statutorily authorized to represent these clients in their attempts to obtain public records in civil actions, and moved to dismiss it on those grounds.
Which records are you claiming that you should have had that you don't have?
Your Honor, as to the Florida Department of Law Enforcement, the investigative or 1A file, the action to obtain the 1A file was filed, I believe, within a very few months, if not weeks, after we first learned that the Florida Department of Law Enforcement maintained an investigative file, which it did not turn over when we made our general request that they were expecting a specific request as to investigative files.
You got that one?
Your Honor, I believe that what happened regarding the investigative file is that when this court first proposed Rule 3.852, returning jurisdiction, with a means of returning jurisdiction to the trial court, that the action was voluntarily dismissed in order to present the claim to the circuit court. Of course, the circuit court had already ruled by that time. So those records have not yet been produced. In all candor to the court, I will tell the court that the Florida Department of Law Enforcement, when they answer these complaints, many times it turns out that they don't have an investigative file, a 1A file. And rather than coming into court and saying there is no 1A file for this particular defendant, they come out with general denials and motions to dismiss, and it takes us months to find out that we're fighting over nothing. Now, hopefully this court's Rule 3.852, will put an end to this kind of waste of time, but it occurred in this case. The Department of Corrections matter, which was also pending at the time, we have obtained those materials.
You were trying to get something from the Parole Commission. You lost on that.
We lost on that one, Your Honor, and I don't think we get more time after we lose. That issue's been resolved adverse to us, and we're not asking for more time to get something we're not entitled to. What we would ask, Your Honor, under the circumstances, that this court remand Mr. Valle's case to the circuit court, then instruct the circuit court to resolve the one relatively minor 119 issue, that it then allow Mr. Valle the opportunity to amend his Rule 3.850 motion. Something which I didn't mention earlier, but I should point out to the court, is that the circuit court took the position that Mr. Valle was not entitled to amend his Rule 3.850 motion after the 2-year date, regardless of whether public records were obtained after that date. It's an argument which Ms. Brill, who is the trial post-conviction prosecutor, has consistently urged in Dade County, and the courts down there have accepted a number of times. It's not the law of this court, it's not the law of this state. Law of this state is obtain public records, amend your post-conviction motion, let's get on the road. And that's not what's going on when we have to go back and forth because courts don't follow the clear directives of this. Lower courts don't follow the clear directives of this court. I reserve the rest of my time for rebuttal.
Response?
May it please the Court, Fariba Komeily, Assistant Attorney General on behalf of the state. I think I should start out with a chronology of where we began in this case and get into the issues. The direct appeal proceedings in this matter were completed in December of 1991. Collateral representation began at that juncture. About a year and a half later, in April of 1993, we had the first motion for post-conviction relief, which consisted of headings of claims and a public records claim in there saying that the Dade County State Attorney's Office, various police agencies, various jail agencies, etc., had not provided records to the defense. State filed a response indicating that all the records had in fact been turned over, and there was a hearing about 4 months after the filing of the April 1993 initial motion. At that time, the public records issues were addressed. In fact, defense counsel, Mr. Kissinger, did admit that the state attorney's files, which also included Department of Corrections, City of Deerfield Beach, Metro-Dade Police Department files, police files, were all encompassed in the state attorney's files, that all of those had been provided prior to the filing of the motion for post-conviction relief in April of 1993, that there was no dispute as to any of that. The only public records at this juncture that were mentioned by the defense were that they were requesting records from the Parole Commission, that is the subject matter of the ACIS suit, and that they had filed a suit in Leon County as to that, and that there was also a matter with the Department of Corrections. The matter with the Department of Corrections was that the Department of Corrections had made copies of their records, but that counsel for Mr. Valle did not wish to pay for the copies and therefore had not picked them up.
Well, he says they've got the corrections file. What about the 1A file from FDLE?
There is no indication of any 1A file at this juncture. None. The only two things that are mentioned are the ASA one and Department of Corrections, which is not in terms of a suit. It's in terms of we don't want to pay for copies, at which point the state also points out that, look, Department of Correction files were all provided to prior counsel at the 1988 resentencing. because that was what most of the resentencing was about the disciplinary records, etc., from Department of Corrections. You already have copies of those, and the copies are in our files as well, which have also been copied. Nonetheless, trial court gave the defendant an additional 9 months from the filing of the initial Rule 3 and about 4 months from the date of this hearing that I'm talking about to file an amended motion. An amended motion was then filed, and in the amended motion, the defense said they still had not received records from FDLE, Department of Correction, and the State Attorney's Office. There was another response and another Huff hearing, this Huff hearing being about a year later after this motion, in which there was a discussion of the public records again. At this juncture, again, the only thing brought to the attention of the trial court was the ACIS suit, and that it was now pending in the Florida Supreme Court and had been, I believe, denied, but motion for rehearing pending.
They didn't talk about the FDLE records?
The FDLE and Department of Corrections are mentioned in the following manner. There is a circuit pending against FDLE and Department of Corrections. There's no further discussion. There is nothing in this record, not one word about suit having been filed in Leon County, what the status is, we need more time, etc. In the meantime, we are now, this is August of 1994. It is close to 2 years after the filing of the initial Rule 3, and certainly about 4 years after collateral representation has begun. With respect to the public records suit, as I understand it right now, it's with the FDLE investigative files. The only other mention of this was also in the amended motion, where counsel mentioned that they had received records from FDLE, but that they had information that the IA files had not been routinely furnished, and they may not have been in this case, and they were therefore going to send another request for them. Not that any civil suits had been filed, and certainly there was nothing about the status of where this letter had led or whether there were any civil suits pending. It is my understanding from the argument now presented and in the reply brief that that suit has been dismissed, and it was because of Rule 3.852. I would point out that Rule 3.852 was adopted in 1996. These proceedings were terminated, were final as of January 1995, about a year earlier.
Which proceeding? Oh, this proceeding.
I beg your pardon?
Which proceeding? You mean this proceeding, the one we got now?
Yes, the post-conviction in the trial court. I mean,
Yeah.
I don't understand the logic of coming in and saying, oh, well, I dismissed it on the basis of Rule 3.852, which was adopted a year after these proceedings were terminated. I don't understand that logic or how that has any bearing.
The 119 proceedings were terminated in January of 95?
The post-conviction proceedings were terminated in the Dade County trial court. These proceedings that we are on appeal right now, the post-conviction, the motion for post-conviction relief, was the rehearing was denied in January of 95.
Do you
It
know
was
when
final.
the 119 proceedings were dismissed?
The 119 proceedings, according to what I heard on the initial argument from Mr. Kissinger, were dismissed as a result of Rule 3.852 and pursuant to Rule 3.852. Rule 3.852, if I'm not mistaken, went into effect October of 1996, more than a year after these proceedings had been terminated. So I don't understand the logic of saying, oh, well, we had a suit pending that we dismissed a year after the post-conviction proceedings were brought because we wanted to include those in the post-conviction proceedings, because that's the provision of Rule 3.852. It doesn't say you have to dismiss. It says if you still have post-conviction in the circuit court, then you can transfer. Those civil suits will be transferred. If they're not transferred, and CCR does have an option of objecting and not letting it be transferred. they apparently, from what I'm hearing at oral argument, is they apparently did not exercise that option, as in they took a voluntary dismissal, but I don't understand why. There was nothing pending in the circuit court to take it to. And the point remains that despite this date, first of all, it was defense counsel who told the trial judge from the very inception of these proceedings and throughout these proceedings, Judge, you don't have jurisdiction over civil suits in Leon County. It is not the trial court who said, I don't have jurisdiction. It is counsel for the defendant who said from the very inception, from the first August 4th, 1993, initial hearing that we had, you don't have jurisdiction over any other outside agencies. Everybody who's within your jurisdiction has already complied, but those outside agencies give us a reasonable time. Judge says, how much is reasonable time? They don't exactly specify. The judge gives them another 4 months from the date of the hearing, 9 months after the date of the initial motion to do all of this. And yet throughout, there is no mention of any civil suit with respect to FDLE and Department of Corrections or the status of any of this. To come in and say, oh, well, a year after these proceedings, yes, there was in fact a suit which we never brought to the trial court's attention, and then we turned around and took a voluntary dismissal of that suit, and still to this juncture not specify what is it that you're asking for that would allow you to amend. What is this information? After all, you did take a voluntary dismissal. What is this information? I don't think any amendment ought to be allowed at this point. I think more than a reasonable time was given to counsel. Nothing was brought to the attention of the trial court, and at this juncture it is too late, especially since a voluntary dismissal has been taken. With respect to the lack of an evidentiary hearing in these proceedings, it is our contention that no evidentiary hearing was required because these allegations were either procedurally barred or insufficient. I'll go through the instances brought up by Mr. Kissinger. The first one of which is that the trial court had an ex parte communication with the prosecutor and was biased because he had been seen kissing the victim's widow. There was a Huff hearing in this matter, and the trial judge went through these allegations and said, what is it that you're relying on? What is the basis for these allegations? Trial counsel's counsel for the defendant's response was, the specific facts don't need to be, affidavits don't need to be, names of witnesses don't need to be attached, nothing. Counsel was not about to specify these allegations, and let me point out why it's important. The sum total of the ex parte allegation is that the trial judge had been seen having what appeared to be an important conversation with the prosecutor in the absence of defense counsel. That was the sum total of the ex parte.
That may not be sufficient as a matter of law.
It is definitively not sufficient,
The
Your
other one
Honor.
probably is sufficient as a matter of law.
The kissing of the victim, this is, again, the trial judge asks, what is the basis for this allegation? I mean, where is it coming from? I know counsel at oral argument just now proceeded to quote that it was trial counsel who would have said something. But when the trial judge asked below, this is at page 58 of the transcripts, I don't know, I'm not sure, and counsel's position was, I don't have to tell you. You have to give me an evidentiary hearing first before I come up with any basis as to even the name of a person. And I would point out that there wasn't one trial counsel in this matter, there were 3 of them. It's still not specified. But let's take those allegations and why it's not sufficient, even as to the kissing of the victim. The underlying legal claim is that trial counsel knew and did not ineffectively fail to object or did object and failed to disqualify the trial judge on the basis of the trial judge having kissed the victim's widow. Well, for those allegations at trial, if trial counsel had made such an allegation in a motion to disqualify at the time, it would have required 2 affidavits and a certificate of good faith. You cannot, in post-conviction proceedings, come in and say, This motion for disqualification on the basis of the victim, of the judge having kissed the victim's widow, should have been brought up at trial and a motion for disqualification filed without even bothering to name who made this allegation. If trial counsel was ineffective for having failed to do so, he would have had to provide 2 affidavits and a certificate of good faith. We have a situation in post-conviction proceedings where not only are there no affidavits or a certificate of good faith, we don't even know who's making the allegations. So that is why it's insufficient. That allegation too is insufficient. You cannot come in and complain about something that wasn't done without you at least making some effort to comply with the procedures that were in effect at the time of the trial. As to the ex parte, just simply saying that the trial judge at the time of the post-conviction proceedings gave counsel an example, said the counsel's position was, even if the trial judge had been observed asking the prosecutor, how was the Marlins game last night? Or just saying good morning in the absence of defense counsel, that would require an evidentiary hearing. This is on the record, it's quoted in my brief. I mean, that is clearly not the law. You have to have the specific factual allegations. And the trial judge, having had a Huff hearing 2 years after the initial motion is filed, is specifically asking, specify your factual allegations. Judge, I don't have to. I don't have to unless and until you give me an evidentiary hearing. What is the source of these allegations? I'm not going to tell you unless and until you have an evidentiary hearing. And I submit to you that that is clearly not the law. The specific factual allegations have to be made, and in the context of things when you're making allegations that judicial bias required disqualification and counsel should have filed for disqualification, then you comply with the procedures that were at the time of trial, which requires not only the name of the witnesses who witnessed these things, but 2 affidavits and a certificate of good faith. That was the law at the time. That's why these allegations were held to be insufficient. The next instance is the ineffective assistance of counsel with respect to the Skipper evidence. This defendant had a first trial shortly after the time of the crime in 1978, where one judge and the jury recommended a death sentence, and it was reversed on appeal. There was then a retrial in 1981. Another judge and another jury with a 9-3 recommendation of death came back, and that was affirmed on appeal. In the course of that trial, family background evidence had been presented as mitigation by the same attorneys, incidentally, who had been handling the resentencing in this case, in addition to some model prisoner testimony, which had not been rebutted by the state. They had wanted to also present additional model prisoner testimony as to future good behavior for Mr. Valle that the trial judge had not allowed. On direct appeal of this retrial, this court affirmed everything and said that future model prisoner testimony would have been cumulative because some model prisoner testimony had been entered into evidence. You affirmed. It went up to the United States Supreme Court, which remanded for consideration in light of Skipper. The small problem referred to here, as in the escape attempt with Mr. Bundy, had already occurred by the time of the remand. In fact, the state attached some of those papers in the rehearing and advised this court that, look, the future model prisoner testimony doesn't mean anything in this case because there's been an escape attempt and numerous disciplinary proceedings. Nonetheless, this court, pursuant to Skipper, reversed and remanded. On remand, as pointed out by the allegations in the motion for post-conviction relief, there were 4 attorneys involved. One of them was Mr. Zellman.
4 defense attorneys?
I beg your pardon?
4 defense attorneys?
4 of them. Mr. Scherker, Ms. Gottlieb, Mr. Zellman, and Ms. Georgie. During a pretrial, before the resentencing proceedings began in the presence of the defendant, counsel argued that Judge, the state should not be allowed to rebut our model prisoner testimony with evidence of this escape. Trial judge denied the motion. This is all in the presence of the defendant. Then, as pointed out before resentencing, as pointed out by counsel for the defendant in the motion for post-conviction relief, Mr. Zellman had disagreement with the other three counsel as to whether this evidence should be presented, and he stated, I'm not going to participate in this if you're going to present this. This is in the motion. These are the allegations of the defendant himself in the motion for post-conviction relief. At this juncture, trial court held a hearing, and there's a 10-page colloquy, which I've quoted in my brief, with the defendant as to whether he understood the ramifications of Mr. Zellman's departure. And Mr. Zellman, even according to defendant's own allegations, is departing only because of the disagreement as to the skipper evidence. And we have at the end of that 10-page colloquy, where counsel currently state there was no waiver. This is counsel for the defendant. Back on the record, Ms. Georgie, have you discussed this with Mr. Valle? And this is in the middle of this 10-page colloquy. Yes, Your Honor. There is no question in your mind that he understands all the ramifications, and he's satisfied and wishes you and Mr. Scher and Ms. Gottlieb continue to represent him without Mr. Zellman, the defendant. Yes, sir. And counsel also agrees and says, yes, Your Honor. And Mr. Valle agrees to that, and you all understand, and he understands that that's what he wants to do. Yes, Your Honor. You do understand that at some later time you will end up giving your right to complain that Mr. Zellman was not here. Defendant, I understand. Are there any questions you want to ask me about that, Mr. Valle? No. Anything that you don't understand at all? No, I understand it. Counsel for the defendant points out we've had hours of discussions about this. This is about as clear a waiver as you get. But the second prong of this is an ineffective assistance of counsel claim. This is a defendant who had a prior trial where everything was affirmed. The same evidence, model prisoner testimony, family background testimony, etc., was presented at a prior trial. Some model prisoner testimony was presented at a prior trial without any rebuttal by the state, and there was a 9-3 recommendation of death, a sentence of death by a different trial judge, and it was affirmed in this court. I failed to see the prejudice of coming down at the resentencing, having all that same evidence plus the rebuttal by the state, and this time you got an 8-4 recommendation. It's just, even if the model prisoner testimony had not been presented, there is no prejudice.
Before you sit down, let me ask you what the state's understanding or knowledge is about the delay between the time that the rehearing was denied in January of '95 and the time that the notice of appeal was filed in this court 18 months later.
My understanding of the record was that there was a hearing on the motion for rehearing, and the order was submitted at that time. It was signed at that time, and counsel certainly had notice of it. My understanding of it had been that the notice of appeal was somehow lost or mislaid by the clerk's office thereafter, not that there wasn't any notice of the order. That had been my understanding.
There was no motion to dismiss this appeal filed. Is
No.
that correct?
No.
Thank you.
For the remainder of the arguments, I would rely on my brief, and unless there are any questions, thank you.
Rebuttal.
Thank you, Your Honor. Your Honor, very quickly, just to clear up a few things. The civil suit against the Florida Department of Law Enforcement was dismissed, not just by Mr. Valle, but with agreement of the parties, and it was when this court first issued the proposed Rule 3.852.
Well, let me ask you this, Mr.
It was dismissed in anticipation of the enactment.
As it pertains to the allegations concerning ex-party communications and the allegations concerning the matter of the failure to disqualify the judge, why wouldn't it be a requirement that the allegations in the motion must be at least sufficient to establish what the circumstances are that were communicated during the ex parte communication? Don't you have to allege that there were conversations pertaining to the case ex parte?
Your Honor, that does happen to be the weaker portion of the judicial misconduct claim. However, I do think that there is a problem.
I mean, the fact that there are communications with the lawyer, with the judge, or with the prosecutor, with the judge, which may be totally, don't you have to, related to totally another case and not have anything to do with this particular case? Don't you have to allege that it's ex parte communications concerning this case in order to be sufficient?
Your Honor, as I understand the rule on disqualification, the nature of the evidence which must be alleged to justify disqualification is that it would cause a reasonable person to be concerned about judicial bias. What the
my
allegation
is that you have to make allegations concerning an ex parte communication concerning the case, don't you?
Your Honor, in terms of ex parte communication, but what the allegation is in this case is that trial counsel saw, in the middle of his trial, saw the prosecutors and the judge in the trial coming out of chambers discussing a matter of importance. Now, when you have a situation where Mr. Valle is not in a position to know what goes on in it,
What
went
were
on in
they
those
discussing?
chambers. Your Honor,
What were they discussing?
Mr. Valle is not in a position to know that. He is in a position
Well,
to
you
know
made the allegation. You
communication.
signed the allegation, did you not? What is your evidence?
Your Honor, we signed the allegation, and while the allegation may not, while as Justice Overton has queried, is the allegation what's alleged sufficient, that's an issue which the court needs to resolve. Our allegation is that it was a matter of some importance. It was took place in chambers. It took place during the course of the trial.
What was the procedure in 1988 to file a motion for recusal?
I believe at that time it may have actually been what counsel just represented, the two affidavits, because I do not believe there was significant amendment prior to the most recent rule of judicial administration, if I recall the rule correctly, Your Honor. Your Honor, there are a couple of, I do see that my time is up.
Do we have a jurisdictional problem in this case?
I do not believe we do, Your Honor. I don't believe there's even an argument that we have a judicial problem, and that's why the jurisdictional problem, and that's why the state hasn't raised it. There was...
The state of the record, state of the docket sheet in this case is that the motion for rehearing was denied 18 months before the notice of appeal was filed. Isn't that right?
Your Honor...
That's the state of the record.
State of the record, Your Honor, but as counsel has explained, as I explained, there are actually two components, because counsel is correct. There was also the problem with the clerk of court failing to file the notice of appeal in the manner that they're required to do. But there was also the matter I explained to the court, which is that the court enters the order and we leave Miami, we go back to our office, and we wait for the thing to be served so that we can get the ball rolling, and they don't serve, and they don't serve, and they don't serve it. Your Honor, I don't want to just go out and lash out at another judicial body, but that clerk's office has got problems. And this kind of stuff happens all the time.
Let me, one other thing. This FDLE 1A file, whether it exists or not, that would be related to guilt. Guilt's been decided 10 years ago. We're dealing with whether or not there's something that can help you in the penalty phase.
Your Honor, our concern is Mr. Valle's counsel this time is information relating to the escape attempt and any activity any investigative activity undertaken by FDLE at that time. There was some physical evidence components to that escape. I don't know if the court recalls or if the matter had ever come before the court, but my understanding is that there had actually been, bars had been partially sawn through, and as I recall, and I hope I'm not getting confused with another case, but black grease had been taken into it, so there were a number of forensic aspects to that escape attempt that may not have normally been present in the where the escape attempt is detected at an earlier stage, and it's just a matter of basically conspiracy. So we believe, if there's nothing in there, Your Honor, if there isn't further information, well, we don't get to amend.
Court understands.
That's what the law is.
Nothing further to come before this court. This court is hereby adjourned.